Other time zones that are not Eastern Standard Time. My name is Glenn Lambie. I'm Chief Counsel of the Foundation's Legal Studies Division. For those of you not familiar with the Foundation, we are a nonprofit public interest law and policy center that is celebrating its 41st year this year of full-time advocacy for free enterprise values, limited government, and the rule of law. The many things that we do here, in addition to putting on programs such as this, include litigating in federal and state courts, amicus briefs and original actions, filing regulatory comments. Also, we have a very vigorous publications program. We've actually got a paper coming out from our moderator today at the end of this week that I hope you are interested in reading. And the issues that are going to be discussed today, I think, really touch upon a lot of the issue areas that the Foundation cares about: cybersecurity, standard setting, regulation, product liability matters. So we're really pleased to be starting the year out with a program, I think, of this breadth and interest. I'm going to introduce Michael O'Brien, who's going to be our moderator today. He's a partner with Wilson Elser in the firm's White Plains, New York office. He's co-chair of the firm's product liability, prevention, and government compliance practice. He's also a member of the Information Governance Leadership Committee with more than 30 years of experience in product liability defense. Mr. O'Brien focuses on representing U.S. and Asia-based manufacturers and distributors as national counsel in litigation, pre-suit investigations, and class actions. He also advises clients on reporting obligations to the U.S. Consumer Product Safety Commission and counsels them on voluntary recall issues. Michael, if you could get us started. Thank you.
Sure. Thank you for the introduction, Glenn, and thank you for the opportunity to participate and moderate this program today. Let me introduce the audience. We have a variety of different interested stakeholders who are going to be participating as part of the panel today. And even though the breadth and depth of the experience of these individuals and the different areas that they come from is itself interesting, it's only a sliver of how big the Internet of Things is and how big the landscape is for the Internet of Things. There's 8 billion products supposedly connected to the Internet this year. 5 million per day get connected to the Internet. So the growth rate of the Internet of Things is exponential. So you can think of anything that can be connected to the Internet theoretically will be connected to the Internet someday. And the driving forces behind that are efficiencies, collecting data, monetizing the use of data, enhancing the benefits, and a wide variety of things that will improve the lives of many people around the world. However, with that comes certain concerns. And technology historically always outpaces the ability of regulators and other stakeholders to kind of hold back on how much of an impact the advancing technologies are going to have. And so again, today what we're going to do is we're going to have a nice panel discussion, hopefully a lively debate. Hopefully you're going to learn some things about what's taking place. And let me begin by introducing our current panel. Julie Carney, to my right here, is the Vice President of Regulatory Affairs for the Consumer Technology Association. This is the technology trade association representing 321 billion U.S. consumer technology industry. She represents CTA's 2,200 member companies before the FCC, the FTC, the FDA, and other government agencies. Prior to joining CTA, Julie held positions in government affairs at NPR, in MCI's International Affairs Group, and as an associate at Haley, Bader and Potts, now Garvey, Schubert and Baer. She serves as the president of the Federal Communications Bar Association and is a past chair of the FCBA Foundation and a trustee of the CTA Foundation. Our next panelist to my left is Jim Trilling. He's a senior attorney with the Federal Trade Commission's Division of Privacy and Identity Protection. He previously worked at the FTC's Division of Advertising Practices. At the FTC, he has led policy initiatives, investigations, and litigation enforcement actions involving a wide range of consumer protection issues, including online privacy, data security, and the installation of malware on consumers' computers. Before joining the Commission, Jim litigated a variety of cases at a law firm in Washington, D.C., and then he clerked also for then U.S. District Court Judge David F. Hamilton. And last but not least is Courtney S. Young, who is the Senior Attorney for Risk Management at Medmark Insurance Group. Her primary responsibilities include the development of resources on product liability avoidance and regulatory correspondence with brokers, policyholders, and underwriters in efforts to evaluate and mitigate product liability risk. Courtney works with drug and device makers, component part manufacturers, and raw ingredient suppliers before and after product liability claims to identify and assess their product liability exposures and mitigate future liability. And I might also add that Courtney actually told me she interned here several years ago when she was a law student before going to work in the legal profession. So welcome back, Courtney.
Thank you. That's great.
So let me begin. Julie, you were out at the Consumer Electronics Show in Las Vegas earlier this year, and that is one huge program, conference that goes on for several days in Las Vegas. And when I first started doing my research on the Internet of Things about 3 or 4 years ago, one of the first things I came across was an article about how many different products were being advertised, displayed, and showcased at the CES program. So having just come back from that, maybe you could share some information with those who are listening about what was going on at that conference and how big the Internet of Things has been playing at that conference.
Okay. There are, and thank you for the lovely introduction, CTA, the Consumer Technology Association, my employer, puts on the Consumer Electronics Show, otherwise known as CES. And this year we had 3,900 exhibiting companies, 170,000 plus attendees, 7,000 plus media, and 2.76 million net square feet of space. That is a very large conference. I certainly didn't get to see it all, but I would say IoT is everywhere. It has grown exponentially in the last few years. We were talking, I was on a panel last week about CES and the tech that people saw, and it was sort of, since you've been going, I've been going since 2004, what has changed? Well, in 2004, it was, and still is, big TVs and sound systems. 2 years ago, or 3 years ago, it was 3D printers, and now, of course, everything is connected. And I'll tell you what some of the big things were. So smart home is an enormous category now. The Googles and the Amazon Echo, your digital assistants are huge. Artificial intelligence, robotics, anything from having a robot help you around the house to having a robot be your friend, which I thought was really sweet. Wearable tech, fingerprint tech, self-driving cars. So we had several exhibitors this year. Last year was one of our big sort of launches of self-driving, but this year it was really, I wouldn't say mainstream, but we were really, really focusing on self-driving. And of course, drones. These are all connected. You can have, I don't want to, there's the wow sort of fun factor stuff, and then there's the stuff that's really, truly life-changing that I'll let Courtney talk about. But some of the fun factor things, an Alexa-capable smart fridge that can tell you what's in your fridge, what you need, what you can cook with. One of my favorites is the sort of like the vacuum cleaner guy, but it'll mow your lawn. And then you have, tech that you can attach to your children, so they have a little wristband, so you know where your kids are, and if there's an emergency or something, they can call you. Things for if you've got aging seniors in your life, for them to continue to live independently. There's a lot of sensor technology. Intel did a whole drone show at their keynote with all synchronized drones. I don't remember how many there were, but it was really, truly phenomenal. But just those are the fun wow factor things. But ultimately, everything is connected. If you can think of it, it'll be connected.
Well, with that, we now know that there are security vulnerabilities with the Internet of Things devices, especially on the low end of the tree. The low-hanging fruit, the routers, the security cameras, the things that don't have a lot of computing power necessarily. With this growth that's taking place, how concerned is the consumer industry out there at the show and in the meetings that you have with people with ensuring that these devices are safe from hacking or other security concerns, even theft of personal information?
So I think, I don't know if you said it or Glenn, I think you said it before, that the technology is happening so rapidly and we're trying to keep up with, the hackers are trying to stay one step ahead of them. There are two components to this. So there's how we design the products and how we build security in from the ground up, from the development stage, to what consumers do with their tech in terms of securing their devices, changing their passwords. If you can't change your password, I'm sure your 5-year-old child can do it for you. So obviously we're concerned. We work with the government agencies, NIST, DHS. We've put out an IoT guidance document with DOJ on securing your Internet of Things devices. We're working with NTIA. They've just released a botnet report on which they're collecting comment now. So I think there are two. There's the building and designing of devices and making sure that we are making them as impenetrable as possible, but also empowering consumers to take security into their own hands. I'd be completely remiss, of course, if I didn't talk about, which you will talk about, the FTC has done a tremendous amount of work, and we've also worked with them very closely, but I don't want to steal Jim's thunder, but the FTC has done phenomenal things in terms of educating the consumers, but also to make sure that as industry we are responsible and taking privacy and security into our own hands.
And that's a great lead into a question to James. One of the early articles that I read about was a publication in February 2015 from the FTC. I think Safe Connections is one of the references to that particular publication. And it seems that the FTC in the consumer area has been, to my way of thinking, the federal agency that's leading the charge more so than other federal agencies. Not to suggest that they're not actively involved, but the FTC seems to be really focused on taking measures to protect consumers. So I was wondering if you could share with the listeners and the people here in the room, what are some of the most significant Internet of Things security issues that are currently of concern to the FTC?
Sure, I'd be happy to. And at the outset, I need to say that my remarks today are my own and don't necessarily reflect the views of the Federal Trade Commission or the individual commissioners. That said, in terms of issues that are of concern to the FTC, Julie talked about security by design and building in security as a fundamental part of the development process. That is certainly something that we encourage businesses to do and continue to, in our investigation, see instances where some businesses are failing to do that. Entailed within that, I would highlight, as is demonstrated in some of the complaints that we brought, basic issues like failing to conduct reasonable security tests before releasing products into the marketplace, failing to address vulnerabilities that are identified in those tests and for which there often are low-cost, widely available mitigation steps that can be taken but aren't. Another issue that we've highlighted is the use of hard-coded default passwords or credentials that can provide the ability to control an IoT device without either requiring consumers to change those passwords when they deploy their product or without providing any guidance to consumers on how to do that. That's been an important issue in our IoT-related work. Also, issues with respect to vulnerabilities that may not be identified until after a product is released in the market. We've certainly encouraged businesses to think through how they're going to provide security updates, whether it be in an automated fashion or if it's not in an automated fashion, how consumers are going to be alerted when a patch or an update exists, and how they're going to receive guidance on how they can obtain it. Those are some of the most fundamental issues that we've focused on and that I think will continue to be priorities.
I think you touched upon it, but the FTC can actually bring legal proceedings against companies that the FTC feels is violating Section 5 of the Federal Trade Communications Act, correct?
Right. Section 5 of the Federal Trade Commission Act prohibits both deceptive and unfair acts or practices in or affecting commerce. Certainly applies to the IoT space and applies throughout most of the economy with a few jurisdictional limitations. We also enforce other laws that also apply across technologies, including IoT, for example, the Children's Online Privacy Protection Act, commonly referred to as COPPA, which requires businesses to obtain verifiable parental consent in order to collect information from children under the age of 13. And also requires that the information that's collected from children be reasonably secured. Just in the last week or two, we announced a case against a connected toy manufacturer called VTech. And that case amplifies that protection of information collected from children certainly continues to be a priority at the Commission.
So you mentioned during your remarks, I think the phrase command and control, and that's one of the things that distinguishes the Internet of Things from your traditional cyber threat for hacking of a computer system or a database in which there'll be an infiltration and then personal information or documents of some type, intangible property, if you will be exculpated and utilized for criminal benefits or personal use. But with command and control, we get into a whole different realm of potential concerns where command and control can impact on how the device or the product will actually function and whether it will be functioning as intended to function, or if it doesn't function the way it's intended, do you have adverse consequences? So Courtney, you're in the insurance industry and your customers are healthcare industry, businesses. And so when you look at a medical device that could be connected to the internet and then implanted in somebody, like an insulin pump or a heart monitor or other types of medical devices, as an insurance executive, what types of things are you and your company looking at and concerned about?
Yeah, so I think, the point that you raise is an excellent one. And I think, especially in the healthcare industry, the emphasis has really been on the release of patient information and how we can protect devices against that and how we can protect patient information. But the command and control aspect, and that is the aspect that these devices are vulnerable to infiltration, hacking, and actual manipulation, and thus, adverse effects on patient harm and patient health are something that I think maybe at least outside the healthcare industry looking in are underemphasized. So in my line of work, because medical device companies are our policyholders and we're really insuring for products liability, we're really looking chiefly at how can these devices be vulnerable and what does that worst case scenario look like if they are vulnerable. So we're definitely looking at, what are all of these devices connected to, because they're as vulnerable as the most vulnerable device in that, Internet of Things that they're connected to. What does the worst case scenario look like? What is the adverse health outcome that is possible were this device to be manipulated? We do look at patient health information and if that's exposed and if that's vulnerable, what does that worst case scenario look like? What kind of controls does the company have in place to mitigate this risk? Of course, regulatory compliance. Are they, acting to the letter of the guidance documents put out by FDA? So all these kind of evaluative steps to see, and I think the biggest one is, have they, the insured, the medical device company, appreciated this risk? And then that's kind of the first step to know even, if they've adequately addressed it. Do they understand that this is out there? And I'd say, this is a question that you didn't ask, but for the most part, I'd say they really have appreciated this risk. I think we have a lot of small companies that are making a mobile app, and maybe this is their first foray into the healthcare industry. They may not even realize they're making a regulated product. And they're asking for consumers to enter their health information, not realizing that there's a HIPAA concern, or that brings them into the purview of all these different regulations and regulating bodies. So I would say the risk there is underappreciated, and we're certainly evaluating that too.
Right. So it's interesting because we can foresee that if you take a medical device, there's going to be potential product liability risks associated with it. I mean, that's just a given with any kind of device that has the potential, if it fails in the normal course of an anticipated failure. But then when you add the overlay of the potential for hacking or the potential concerns about the information that the device may be generating being used for other purposes, maybe benign purposes, but nonetheless, when you start taking, say, tens of thousands, if not millions of devices connected to the internet, and one or two institutions can harvest that information, it does create some concerns on the privacy sector. So it's sort of like we're talking about three separate areas of concern when you look at a medical device that could be implanted. You're talking about your traditional product liability concerns with a failure. You're talking about the vulnerability that can exist because some bad actor has the possible entryway to take command and control of that device. In fact, former Vice President Dick Cheney reportedly in 2013 in a 60 Minutes interview on the advice of his doctor disconnected his heart defibrillator from the internet in order to prevent that potential misuse against him as a means of an attack. And then you've got the whole concern about data, and data generation and monetization of data is one of the biggest things that is behind the growth of the Internet of Things and why so many different businesses are interested in getting on board with the Internet of Things. You did mention, however, a different federal agency. So when we begin to talk about different federal agencies having different oversight over different sectors of the Internet of Things, with regard to medical devices, you're talking largely about the Food and Drug Administration, correct?
Correct.
Okay. And they've issued some guidelines, have they not, on certain types of practices that should be followed by companies that are starting to get involved in interconnectivity with medical devices?
They have, yeah. So they are just guidance documents at this point, but they've released a guidance document on pre-market measures that medical device companies should take to ensure cybersecurity, and then one on post-market. And it largely has to do with threat detection and monitoring what's going on, and then the different testing that companies should be undertaking. The FDA is very clear in the fact that they are not doing medical device or cybersecurity testing. Rather, this is squarely on the shoulders of these device companies, and the FDA expects communication and cooperation when a device company becomes aware of any possible threat. So I think their biggest role to date has been collaborating with companies when a threat is detected. So for example, probably the biggest one is the St. Jude recall of almost 500,000 pacemakers because they identified the possible vulnerability of hacking that could manipulate the device. And then FDA plays a big role obviously in publicizing that and not so much coordinating the recall, but ensuring that loop is closed and that all the devices have been recouped. And I think that they'll continue to play that role. I don't see, in the absence, I guess, of some big adverse event that affected a lot of people, I think the FDA will probably remain relatively hands-off and continue to put these guidance documents out and work with industry, but they're not going to step in and become the tester of these devices or otherwise ensuring that cybersecurity flaws aren't existent.
So Julie, going back to your interest in being involved in a trade association that's focused on consumer goods, consumer electronics, from your point of view, what role can policymakers play in delivering an environment for IoT business models to thrive, on the one hand, and then how can they help businesses to develop in line with, say, this administration's focus on increased competitiveness and productivity?
That is a great question, and I think what we found, we always tend to like industry to take the lead on developing principles and letting our products flourish, but we understand that the government can't just walk away and turn a blind eye. So we've had really important partnerships with the agencies I mentioned before, FTC, NTIA, NIST, DHS, DOJ, and they're in a good position to understand a really big picture in the intergovernmental piece, and we're in a good position to understand how products are being developed. And I think we have a good level of communication happening. NTIA has organized stakeholder workshops for botnet attacks. FTC has done similar stakeholder groups and held a lot of workshops. So I think a lot of it, these are new, this is new territory, this is new ground, and I think it's really an important collaboration. We prefer for industry to take the lead, but we're very happy working with our government partners. In fact, a lot of our government folks are able to come to CES and to really see the products and understand the impacts that they're having. It's important for us to get policymakers out of DC so they can actually have some hands-on experience with the products as well. So we're committed to ensuring that we're creating the safest environment. CTA has a whole tech and standards department, so we're working on standards. We did a whole connected home guidance and their associated standards with that. So in another standard, whereas products mature, that they're not being sort of left vulnerable to hackers. So we're all in this together.
It's interesting because unlike, say, other advances in technology that might have a very narrow focus, the Internet of Things covers so many different areas of commerce and industry in terms of its landscape, and so many different federal regulatory bodies having some oversight over it, as well as so many different trade associations, that the real, it's a tsunami of technological advances across a very, very broad landscape. And trying to grapple with all that seems to me to be one of the fundamental challenges. I think we may see single sectors advancing further than other sectors in terms of how they can develop the framework that will ensure certain levels of security, privacy, and safety. But I think it's going to be kind of in fits and starts, perhaps.
Yeah, and I think the key for us is to have, we did an IoT paper advice for the next administration, so we released this last October, and it was really to have more of the intergovernmental cooperation and to have different agencies talking to each other. So FDA isn't off doing one thing, and FTC has its, and I know, Jim, you're heavily involved with the interagency stuff, but to keep that momentum going so we know where to go. At what we did I think this is common knowledge, but there were like 30 congressional committees that have covered connected devices. And then we have a lot of people with a lot of different interests as well. So it accounts for a lot of billable hours.
Well, let me switch then over to Jim, because what Julie's comments are talking about cooperation amongst different government agencies. So what is the FTC doing to work with other agencies on things like Internet of Things security?
Sure, and I didn't get a chance to interject specifically when Courtney mentioned mobile health app developers. That's a good example. The FTC, in consultation with HHS, did put together guidance to help mobile health app developers learn more about the legal landscape and what statutes or rules might apply to their conduct and the products and services that they're offered. And that online interactive tool is available on the FTC website, and I believe also on the HHS and FDA websites. Stepping back more broadly, We regularly interact with our counterpart agencies that also have a stake in the IoT space. That can be through formal arrangements like memoranda of understanding that we have with some of our peer agencies that set forth enforcement priorities where there may be concurrent jurisdiction, also provide for the sharing of information so that investigatory work, for example, that we're doing can be efficient both from the agency standpoint and from the entity that is being investigated. There are mechanisms in place where we can share information confidentially in order to advance investigations. And then from a policy standpoint, a policymaking standpoint, we frequently convene joint workshops or participate in multi-stakeholder processes, as Julie had alluded. For example, we, in partnership with NHTSA, had a workshop on connected cars late in 2017, and just in the last week or two issued a staff perspective summarizing some of the key takeaways from that workshop. We regularly participate in the NTIA, National Telecommunications and Information Administration, multi-stakeholder processes. In the last 2 years in the IoT space, for example, we've provided comments about vulnerability disclosure, about transparency for providing consumers with information about whether security updates are going to be available, how long they're going to be available, what the effect on an IoT device might be when support is no longer provided. We also participate in various NIST proceedings and provide comments where we have expertise to offer a business guidance piece that we published in the last year or two that received a lot of attention. Talked about the commonality between the NIST cybersecurity framework and the FTC enforcement actions in our 60 plus data security cases and our own business guidance in the data security space. So there's a lot of collaboration, and while it's true that there are a lot of stakeholders, I think you see a lot of commonality in terms of the issues and the approaches to the issues among the federal agencies.
So you mentioned concurrent jurisdiction with certain federal agencies, so maybe you could share with us what are some of those agencies that traditionally there's going to be an overlap? Is it like, for instance, the U.S. Consumer Product Safety Commission have in certain instances concurrent jurisdiction with the FTC? Is it other agencies that would also have it in the consumer area?
Sure. I'm not immediately coming up with examples with the CPSC, but I certainly think that that's a possibility depending on the type of product that you're looking at and the different consumer harms that might be in play. Potentially, I could see a scenario where CPSC and FTC might both have jurisdiction and an interest. It more comes to mind with respect to HHS, potentially with FDA, potentially with FCC, and issues of perhaps overlapping or concurrent jurisdiction with FCC, for example, have been in the news and public discourse a lot over the last year with respect to broadband issues. Certainly also with respect to our state AG, Attorney General's offices that often enforce statutes that are similar to Section 5 of the Federal Trade Commission Act. And we certainly collaborate with those offices as well. Sometimes we bring joint enforcement actions. Sometimes we may file separate actions or announce settlements of actions that have been investigated concurrently and are resolved at the same time. So there are, any of a number of ways that concurrent jurisdiction might emerge.
So Courtney, going back to the industry that your company focuses on, healthcare industry, medical product manufacturers, and I'm assuming, and correct me if I'm wrong, but they probably run the gamut of like small, medium, and large, and they're going to have different ways of addressing certain things, different experience levels, different insights as to how these problems, whether it's a traditional product liability problem or the more insidious thing about hacking and privacy. How do you see the industry as a whole dealing with these types of issues when your company is interacting with them and trying to identify the risks and trying to be cognizant of that because you're going to be providing potentially insurance coverage to them?
Right. Well, I think it's probably as you would expect. I think the larger companies that have more resources to devote to this are probably more prepared. I mean, they have huge legal teams that are looking at each of these risks. The smaller companies, of which which compose the majority of our insureds, are not as prepared. And you'll really see it through the agreements between, say OEMs, these large manufacturers and their component part suppliers, or the devices that they're making to be compatible or interoperable with. And you'll really see, liability being pushed down on these smaller companies. And these smaller companies are usually, one, not prepared to handle the liability, but two, not even really familiar with the content of these agreements. And the same goes, I think, for the risks that are inherent in this Internet of Things, because the risks are, even amongst us that are discussing it, still yet to be really identified, really grappled with, really understood how to be mitigated. And I think the same is true of these smaller companies. They know even less about it. So I think, positively, they're really eager for everything that FDA puts out or any of the federal agencies about, mitigating this risk. They understand that it exists. They may not know exactly what it looks like. And I think the bigger companies know a lot more. I guess it's pretty much as you would expect.
Well, some of these littler companies could potentially face extinction if something bad happens, and because of contractual provisions, as they're a supplier of some of the technology that might go into a device that a larger company incorporates. They may not have the capital, or they may not have an adequate insurance policy, or they have signed on to an agreement that is very onerous and flows back against them. So is that part of what the underwriting team at MedMark tries to do, is help guide them through those potential minefields so that they understand that some of these risks could be well in excess of what they could even imagine they could be?
Absolutely, yeah. So part of what I do on a daily basis is looking at the contracts of our insureds and identifying in particular what the indemnification agreements look like and how to kind of restructure those. Although no matter what you tell them, it's not going to change their leverage or bargaining power, and if these agreements may not be able to be negotiated. But I think by and large, the industry is underinsured for the kind of eventualities that we're talking about. I think that a lot of companies think that it's in their commercial general liability policies that's covering everything else, their premises and their business operations, and it's not. Most of these policies contain pretty hefty cyber exclusions. And then they look to their products liability policies like us, but we require physical injury to tangible property. There's been some case law about, really trying, because most of the cases are really insured friendly, so they'll try to make this into tangible property, but it's really not. So, and then even the cyber policies are really dealing with the access and disclosure of information. So I think there's a little bit of a coverage gap here, in that a lot of these companies that think they're protected by their insurance may not be. I'm always advising them to get a cyber policy, but get one that actually contemplates bodily injury and property damage as a result of some of these cyber vulnerabilities. So certainly it's something that we're looking at. It's something that we're trying to communicate. But I think if it's a message I get to the industry as a whole, it would be that you're probably not as insured for these risks as you think you might be.
On the flip side of that, though, I think there's probably an underappreciation with a number of insurance companies that they may actually be covering cyber risks that may manifest themselves in bodily injury and property damage under the more traditional policies that we're talking about. Not a cyber policy, but a comprehensive general liability, a products liability policy, those types of things. And they're unaware of the risk, and they're not getting commensurate insurance premium back because they don't fully understand the risk. And I've heard insurance company executives say one of the challenges about writing this kind of coverage is the insurance industry is very good at looking backwards at things and then being able to figure out from what happened in the past how we can measure risk into the future, and from that get the right premium for that risk. But now we're talking about an industry, a technology that's growing so fast, becoming so pervasive in so many different areas, and we don't have that hindsight yet. And so I think that also becomes part of the challenge with the insurance industry, is that they may be covering losses come a year from now, 2 years, 5 years from now that nobody anticipated that there's coverage for, because somebody's going to fight for coverage in some lawsuit.
I think you're exactly right, and I think the case law that we've seen over the past 3 years, 5 years, even 10 years have told us exactly that, and that is these companies have objected in each of the cases. Some of the really Travelers, Chubb, CNA, and saying there is no coverage for this because it is a cyber exposure, and the court has found this is bodily injury manifesting out of a defect in your product, and it's caused bodily harm, and you're on the hook for it. So I think the pendulum's now starting to swing, and insurers are really recognizing that they may be on the hook for these, and that's where these exclusions are starting to show up, and now they're 1, 5, 10-page exclusions to try to get at any possible cyber risk, whether or not it's the traditional bodily injury that in my view should be covered with these policies. It's something that's wrong in your product, whether it be a misfit screw or a cyber vulnerability. So it'll be interesting to see now how the coverage comes out.
There's an old Chinese refrain, may you live in interesting times.
Yeah, we sure do. Can I add something?
Sure.
Sort of following along on that, I thought the FTC's workshop in December that now Acting Chairman Olhausen wanted to identify informational harms. I don't know if you followed that. Of course you did, Jim, but I don't know, Courtney.
I heard about it.
Yeah, and trying to address, and it's related to IoT, deception or the subversion of consumer choice, financial injury, health or safety, unwarranted intrusion injury, and reputational injury. And the goal was sort of to get a handle on how you quantify those things. I'm sure that would be sort of interesting from an insurance standpoint. I mean, I think she took a very high level, but I think it was an interesting initiative for you all to be looking at. I don't know if you have anything you want to say, Jim?
So that workshop in December, like the typical FTC workshop, had a variety of stakeholders participating from industry, from academia, from consumer advocacy organizations to have a broad discussion about the types of injury that can occur, for example, following a data breach. And some of the takeaways from the event are, as Julie had mentioned, that the range of injury certainly can expand beyond direct monetary harm. Another takeaway was that a number of participants indicated their belief that government should focus its enforcement and other work on issues involving, for example, deceptive representations to consumers, and where the injury is going to be greatest, for example, where the data that may have been breached can be traced to individuals rather than only being aggregate data. Also, where the particular data that was taken could be used in particularly harmful ways. And then another takeaway was that more research is warranted in the area, and I think you can expect the FTC to continue on that track, including we're having our annual Privacy conference at the FTC at the end of February that will include research and discussion regarding the economics of privacy.
So, Julie, your trade association is geared towards, the consumers. And so do the consumers themselves have some responsibility in order to ensure that the products that they're buying that are connected to the internet, that they are engaging in safe, measured practices to not necessarily eliminate it, because I don't think anyone can eliminate, even the companies that manufacture the products, but at least take reasonable steps to try to minimize or mitigate against them becoming vulnerable to something that may exist with one of these products. And I think on average, they say most consumers have in their homes, 6 or 7 products connected to the internet today.
It's probably even more these
Yeah.
days. I think we have we have probably over 25 in my house. But I'm supposed to. I work for CTA, and I love them all. But we did put out this document called Securing Your IoT Devices with DOJ, and I think it actually really sums up the measures that consumers should take. One is do your research, so use a reputable manufacturer. At the risk of upsetting anyone, if it's a $2 device versus one from a manufacturer who may be someone you know a little better that's a different price, anyway, in this case, you get what you pay for a lot of times, and I think we found with the Mirai botnet attack in October, was it 2016 now?
Yes.
Yeah. Gosh, it feels like forever ago. Those were cheap devices, not from a manufacturer that people were quite as aware of. But securing your devices immediately after purchase, these are no-brainers to people in our community. If you have relatives who may not be as savvy on the internet, help them. We've done a lot of triage with relatives to make sure. I'm also married to an IT guy, so we are on speed dial for a lot of family members. But again, adopting secure password practices. Again, it's incumbent on manufacturers to make devices that are secure, again, in their design. But there is sort of a partnership with the consumer to secure your devices too. I know two-factor authentication for your phones is not a bad idea.
Right. So, for instance, you brought up, again, the Mirai botnet attack. And what happened there, from my understanding and reading about it, is that all of these internet devices, routers, security cameras, were hacked because default passwords and default administrative names were being used. They may have been right from the factory. So admin may have been the user, and 12345 could have been the password. Mm-hmm. And there are sophisticated programs using brute force type of algorithms that can identify and break through these passwords. And every year there's a publication about what are the most commonly used, passwords, and don't use these passwords because they're the easiest passwords to hack. And it could be things like hello, it could be ABCD, it's, lots of things along those lines. And so from the consumer standpoint, the idea that if you want to protect yourself and you don't want to become part of a botnet, and some of these people don't even know they're part of a botnet because it's not impacting on how the device functions itself. It's just being used as a botnet army. Take some steps in order to create some passwords that have a little bit of more robust protection and reduce the likelihood that you would become a victim through your own product.
And don't buy the device that won't let you change the password. That's
Right.
another one. And do your security upgrades. I know they can be cumbersome, but it's a good idea.
Yep. So
Digital hygiene.
excellent. Good point. Jim, What do we expect from the FTC this year regarding IoT? Is there anything that's on the horizon that maybe hasn't garnered public attention, but it's part of what the FTC is looking to do this year?
I expect that the FTC's work in this space in 2018 will be similar to an expansion of what it's done in the past. So I expect that we'll continue to conduct investigations and bring enforcement actions in the IoT space under Section 5 of the FTC Act and the other statutes that we enforce. I certainly expect that we'll continue to enhance our consumer and business education. In 2017, we did a series of blog posts called Stick with Security that amplified a campaign we had previously done called Start with Security. And in total, those two campaigns provide a series of what we've referred to as 10 lessons learned from our data security enforcement actions, also from other investigations we've conducted, and our attempt to provide guidance and answer questions that we've received from businesses, including in hypotheticals in the Stick with Security campaign. In the IoT space specifically, I think you had mentioned we do have a publication called Careful Connections, and we'll look for other opportunities to provide business and consumer education. Another initiative that started in 2017 was to provide cyber and other guidance to small businesses in particular. So we'll continue to look to ways to do that. And on the policy side of things, we'll continue to have workshops like PrivacyCon that I mentioned and build on the informational injury workshop. We've also had other recent IoT workshops on drones, on smart TVs. We'll continue to focus on specific technologies and bring together stakeholders to identify issues where we can.
So when you talk about stakeholders, could you just briefly identify, are you talking about dealing with, like, say, large organizations, say, like the U.S. Chamber of Commerce or a trade group, or are you dealing at times getting right down to individual companies and corporations doing these workshops?
All of the above. When we convene workshops, often the panels do have trade associations on them, consumer groups, sometimes researchers or executives or security personnel from individual companies, consumers, academics, representatives of other government agencies, and also we normally have public comment periods in preparation for and sometimes after the workshops. We may issue reports that summarize them where the Commission deems it appropriate, may issue guidance or best practice recommendations that are geared toward enhancing cybersecurity and privacy practices.
So if people in the audience are interested, are any of these things open to the general public?
Absolutely.
And you can, if you can't attend, but you issue a post-mortem report on what was developed and done, people can go on to the FTC website and look for that information and download it and self-educate themselves?
Absolutely. All of our workshops are free and open to the public. We also live stream the workshops when we can, and provide access to the workshop panels in an archived format, and certainly all of the reports that come out of the workshops, and all of our business guidance is available on online. Some of the URLs to keep in mind, ftc.gov/startwithsecurity, business.ftc.gov, and also ftc.gov/subscribe, where, among other things, you can subscribe to the FTC's business blog, which tends to be used to communicate information about our enforcement actions, and also our workshops and other initiatives.
Okay. So, Julie, let's go back to the arena you and I tend to deal in on a day-to-day basis, and we're now looking at an event's happened, some bad outcome from that event has happened, property damage, bodily injury, product liability lawsuit, or at least a claim is being made, but we take it into this arena of internet connectivity so that the device at issue is not a traditional device that could operate dumb, not connected to the internet. Now it's been made smart, so it has some internet connectivity that adds enhancements and benefits to it. What do you see as the challenges? What do you see as the looming difficulty, if you will, with addressing these in a legal context after something bad has happened? And you may have more than your traditional single manufacturer. You may have parties in the supply chain that are bringing some of this new technology into the picture. And so you have an opportunity to kind of like forecast some of your concerns. What do you think some of the issues are going to be?
Sure. Yeah, this is sort of something we've heard from some policy holders, that they're apprehensive because, by connecting to this Internet of Things, does that make them, liable for the different vulnerabilities of other entities that are interconnected? I think what I tell them and what I'd say today is this is not a new area of law. We've dealt with interoperability, we've dealt with component parts, for a very long time, and the law doesn't function much differently because there's the internet here. So, one of the first cases I had when I joined Medmark was a case about lure locks, and there had been an inadvertent connection from a gastrointestinal line to an intravenous line, and it was an awful case that resulted in a premature baby getting formula intravenously. So it was awful, and it was like, well, who's at fault? Is it the maker of the tubing? Is it maker of this catheter port or that? Is it the lure locks that connect them themselves? And really it goes down to very traditional tort liability concepts. Who is negligent? Which manufacturer is advising that they're supposed to be able to be connected? Is there supposed to be interoperability? Who is in the best position to avoid or mitigate the loss? And these are all the same principles that are applied, in the Internet of Things. So I think, I'd say your contracts are really important, and if you've got contracts, that are between interconnected entities about, maybe how you're going to allocate liability in this exact situation, or who's responsible for testing what, how you're advertising your product as being interconnected, or, what manufacturers it's interoperable with becomes important. But I think, they're all established principles of tort liability, and allocating liability is no different in an Internet of Things scenario as before with, manual connections.
Well, what I would say from my perspective looking at this, and again, I'm crystal ball gazing, I'm not actually dealing with this particular situation, but I think that the added complexity of the Internet of Things will make certain functions of the lawyer and the insurance company have to address that. And by this I mean new experts that traditionally have been utilized, say, in some of the product liability cases that we're familiar with may have to come into play because new insights will have to be made. E-discovery is going to become more complex because these devices collect data, and that data then can become a battleground of information about the functionality of the device, whether the device just failed or was it a silent hack that created a problem that led to some type of injury. And that in turn is going to put burdens on companies that maintain that data, how that data is used, and then there's going to be questions about ownership and control of that data. Is it going to be personal data for the individual? Is it going to be the company that supplies the internet-connected device? Is it going to be a wireless carrier that owns that? So that's kind of how I see some of these issues kind of playing out. But I agree with you in terms of the traditional concepts of product liability. Those things will still be applied in the traditional sense to this. And I'd like to see if I can ask one more question before we break, and that maybe take questions from the audience or those who are listening online. So, Julie, you're representing a huge industry, okay, and it's very disparate, even though there's a commonality in it in terms of consumer technology. What are you seeing, though, in the industry? What are some of the benchmarks that you really see some of the top echelon companies who are looking at this, taking it seriously, and want to ensure, because they're protecting their brand, quite honestly.
Yep.
They don't want their brand disparaged because something happens and then all of a sudden they have a big black mark in the eyes of consumers with them. So maybe you could share some insights as to what you're seeing happen.
Well, I think this would sort of be my overriding message, and I've said this, you've probably heard me say it before, but trust is really everything. A lot of these manufacturers and service providers, businesses were built on that. So I would say security, privacy, anything in the realm of IoT and protecting consumers is taken very seriously, but that the overriding goal of IoT is to make people's lives better. It's not to make it more complicated or to add more frustration in our already busy lives. So I would say that our most senior level execs in companies are highly engaged. No one wants, as you said, to have a black mark or to have one incident destroy the entire brand that they've built. So we're working hard with our members to make sure that security by design is fully ingrained in the manufacturing process. But again, it does all fall back to trust.
Okay, thank you. Glenn?
Anyone has a question online, there is a question and answer box that's next to the video screen. Those questions come directly to me, so they won't be seen by the other participants. So if you do have a question, please go ahead. In the meantime, we'll see if anyone in the audience has a question they'd like to ask.
Jim, I think you mentioned that there is a enforcement action that's been brought by the FTC. As a technophobe myself, it always helps, I think, to get a little bit more of the details of the kinds of actions you're bringing, so I can kind of visualize it a little bit better. And in particular, I guess I'm interested in, does the FTC, are you more concerned about when people are allegedly violating Section 5, is it because they have lied to consumers and said something false about the security that they're providing, or are you just trying to establish minimum standards for a technology and it's automatically a violation of Section 5 if you haven't taken enough steps to protect consumers?
Right. So Section 5, as I had mentioned, prohibits both deceptive and unfair acts or practices. Deception is certainly a focus and has been a complaint count or part of the complaint in many of our enforcement actions having to do with data security. Could be anything from a claim to that a defendant has encrypted data when the data wasn't really encrypted, or using a certain type of encryption but not doing so, to a claim of having some other type of security practice in place without doing so. The Commission has also declared that a failure to have reasonable security is an unfair practice, and there have been unfairness allegations in a number of the FTC data security complaints. So an unfair practice is one that causes or is likely to cause substantial consumer injury that is not that consumers cannot reasonably avoid and isn't outweighed by countervailing benefits to consumers or competition. We've looked comprehensively at data security practices in a number of cases where We've alleged in the particular complaint that perhaps a particular combination of what we would deem to be security failings constituted unreasonable security for the particular defendant. When we do that, we look at a number of factors, including the nature and sensitivity of the data at issue, the data that's collected, the size and complexity of the business and its data operations, as well as the availability of tools to reduce vulnerabilities and improve security, and the impact on the particular business of implementing them. So there's not a one-size-fits-all approach of what would constitute reasonable data security, but you will see across our cases a number of allegations in our unfairness counts in multiple cases, and they're sometimes fairly basic points, like failing to have an information security program at all, not doing any employee training, not doing security, reasonable security testing, not taking steps to address known vulnerabilities.
I think one of the companies that was named in a suit recently, I don't want to name them because I may misname them, but the allegations against them also suggested that their vulnerabilities with their devices were comparable to the vulnerabilities that led to the Mirai botnet attack. There wasn't a specific, as I recall in the complaint, an allegation that their devices were part of that attack, but it was the same thing where there was weak security, where there was only admin and default passwords that were very easily hacked, and that could lead to an attack against other businesses. And if you probably Google FTC, IOTC actions, you'll probably come up with several of the settlements and some of the complaints and stuff, because they're easily accessible to the public.
I'm going to ask a question about standard setting. How does that issue play into each one of your roles in all of this, and how does the setting of standards for interoperability purposes lend itself to a whole other range of legal issues as this sort of develops, you think?
I'll take a quick hit on that simply because I've written a little bit on that. So a lot of the stuff that I end up doing can be representing product manufacturers whose products may be failed, it's alleged they failed, and maybe led to a fire. So a lot of consumer goods in the home are powered by electricity. They can get involved in fires, and so we'll do investigations along those lines. One of the guidelines that we use when we conduct fire investigations is a standard by the National Fire Protection Association. It's an NFPA 921 guide for fire and explosion investigations. And every 3 years, it gets revised and updated. And the last revision took place in 2017, and there isn't a single reference in it to the Internet of Things. And so the way I look at this as it handicaps the experts, because let's say a furnace fails, or it's thought to have failed, caused the fire, but it's connected to a smart thermostat. And then the smart thermostat now becomes a potential collateral player in the investigation. If the experts relying on that guideline don't understand that, they could overlook a possible link to what could be the cause. And likewise, Underwriters Laboratories, which has developed standards for every product that's in your home, hasn't yet addressed the Internet of Things in specific products. They have a UL standard 2900 that is evolving and is being used as sort of like a guideline for manufacturers to incorporate into the development of their products that are going to be smart products. But again, things are moving at different paces and at different speeds. And I'm sure, Julie, you have lots of insights as to what some of the different standard organizations are doing and moving along towards trying to find a consensus standard in particular areas.
Well, I think, so, as I mentioned earlier, CTA has a tech and standards department, and we're offering a lot of guidance for, like I said, home networking. We're working with NTIA on the botnet. We're coming up, these are technologies that are changing so quickly. We believe in open standards. We want companies to be working together through and across various industries. So we're working with all the major organizations. That's really all I can say.
Some of the standards, because I've written a little bit on this, National Institute of Standards and Technology,
Working a lot with NIST.
right, Institute of Electrical and Electronics Engineers, International Telecommunications Union, International Standards Organization, ISO.
Yep.
Consumer Reports, of all things, is looking at this issue from the standpoint of their constituency, which is the consumers. They're going to start rating, or if they haven't done so already, products on that, on their safety. There's the Strategic Principles for Securing the Internet of Things, which is the Department of Homeland Security publication.
IEEE.
Yeah. And then there's the Online Trust Alliance, which is another IoT trust framework. So it's happening across a lot of different areas and segments, but I think there's probably a lot of commonality in terms of the aspirational goals of trying to secure the internet so that it is truly beneficial without necessarily any detriments caused inadvertently or unintentionally because of vulnerabilities that just exist in anything that connects to the internet.
And it can't be done in a vacuum, and
Right.
that's really our most important message. And again, we're working with the government folks. Transparency is really important.
I think this is a really hard stage for standards in this area in particular because it is so new and you've got all these different organizations. I mean, for medical devices, NIST is probably the most preeminent, but ISO and Amy's putting out something too. And I sort of have a love-hate relationship with them because, well, it's wonderful to be able to advise, you know, here are these definitive things that you have to do because there's so many of them and no one has quite arisen as the definitive set of standards. It's very easy also in litigation for plaintiff's attorneys to find the one that they didn't comport with and point to that. So right now where they're just kind of propagating, it's a tough area for, at least in my industry, for manufacturers to know what to do and which to comply with, and you really aren't safe unless you comply with all of them, and you can't necessarily do that, so I think it's a tough time.
Right. And even if you comply, they say, the plaintiff's bar, it's a minimum standard.
Right,
And so
yeah.
you didn't
Yeah.
exceed the standard, but compliance with the standard generally is understood to you meet and exceed the minimum requirements. But if there's a cornucopia of different standards and there's some overlapping, to your point, Julie, that's going to be one of the areas of vulnerability. If you comply with one standard, but there's something contained in another standard that ostensibly could be beneficial, or they'll make the argument, but for your failure to comply with that, this tragedy wouldn't have happened, they're going to latch on that.
And for anyone who's not watching us, that's Courtney and I'm Julie. For attribution, right? Anything smart came out of Courtney.
Okay.
Well, thank you, Michael, very much. This program
Thank you.
probably never would have happened if it
Thank
weren't
you
for
to
your
the
help.
panel
And
for
Yeah,
cooperating
thank
and coming.
you.
It was a lot of fun, and I hope that everybody got something out of the program. Thank you.
thank you.
Thank you. Thanks for having me.